There are newspaper reports of a dispute between Virgin and Brightline, but what's happened? Hello, I'm Dominic Walker. Welcome to JMW's Inside Man YouTube channel. Now, Michael Rimola is a solicitor within JMW's intellectual property team. So, Michael, what's happened in this case?
A couple of years ago, 5 years ago now, back in 2018, Virgin entered into a 20-year licensing agreement with a US rail company called Brightline. And in essence, that just meant Brightline could use the Virgin brand on their trains in the US. So I think they called themselves Virgin Trains. And the pandemic then obviously hit the world, and Virgin struggled quite a lot financially, and that was well reported. And in fact, in the UK, they asked the government for a bailout, basically, and that attracted some criticism, given the owner, Sir Richard Branson, is a multi-billionaire. So there was a bit of financial and reputational damage during the pandemic for Virgin. And Brightline, obviously that had a knock-on effect in the US, and I'm sure there are issues there too. And Brightline basically didn't see the value in the license agreement anymore and stopped using the Virgin brand and wanted to end this agreement, and that was back in July 2020. And since then, Virgin have then gone on to sue Brightline for about $250 million for ending that agreement, and that sort of figure relates to unpaid royalties to Virgin for using the brand, or what they would have got if the license had continued, as well as a sort of early termination fee. So that, in essence, that's what's happened.
And nothing's been decided yet. It's not unusual to have license agreements. There's, lots of businesses enter into them. Is it easy to get out of a license agreement then if something does change?
Yeah, I mean, it obviously depends on the drafting of the license. That's the first port of call. But usually there is a termination clause in the license which governs how to end the agreement. But when it comes to particularly high value licenses such as this one, as you can imagine, the clause to terminate would be extremely watertight, and particularly from the licensee's perspective, very hard, if not impossible, to implement. Often license agreements just have the licensor's right to terminate and not necessarily the licensee's. And so, Virgin might have quite a few options of how they would like to end the agreement if they wanted to. But for Brightline, it's a lot more of a tricky situation.
And how can you and the intellectual property team here at JMW Solicitors help business owners who'd like to get some advice in relation to intellectual property law?
Yeah, so obviously we do this day in, day out. And we can certainly help by either drafting the license agreement, or if it's already been drafted by the other side solicitors, we can review it for you and advise you on the implications from an IP perspective. We do often see agreements just generally which have been drafted where there's sort of no consideration for IP rights at all, or if they are, it's probably a generic clause, and that misses a lot of the point with IP. Big issues can be caused, such as this one here, about the sort of value of the brand of Virgin. And if you have an IP specialist involved, I think you can add a lot of value to the issues that might arise. And the value is that they don't arise by having an IP lawyer come in. So we can definitely help with that. And obviously in this scenario, the crux of the dispute really is contract law. But the value of Virgin's brand was obviously the key issue, which led ultimately to this multi-million US dollar dispute.
Michael, thanks for your insight. And if you'd like to contact Michael and the intellectual property team here at JMW Solicitors, you can email insideman@jmw.co.uk or call 0161 82 81 999. I'm Dominic Walker, JMW's Inside Man.